An analysis by Kathleen Schandelmeier Bartels. Who are the parties to the case? They were the New York Times Company and L.B. Sullivan, the police commissioner, who was an elected government official. And this is the photo of the advertisement that was at issue in this landmark case. It was an ad which appeared in the New York Times to benefit the cause of civil rights. The facts. The New York Times published an advertisement called "Heed the Rising Voices" on behalf of the cause of civil rights. Sullivan was certain he had experienced character defamation due to some published facts that were not quite accurately portrayed by the advertisement. Why did Sullivan feel his reputation was damaged by the New York Times publication? Sullivan claimed that the statements in the New York Times advertisement, which alleged civil rights violations, were directed against him because his duties included supervision of the police department. What are the key elements of a defamation claim? The key elements of a defamation claim, according to Charles Crane, 2021, are false statements that are typically defamatory per se, including those that state that someone has committed a serious crime, has an infectious disease, or is incompetent in their job, trade, or profession. Defamation needs to include a third party. It cannot exist without an audience. Because the information was made public through an advertisement in the New York Times, Sullivan was within his rights to contest the advertisement, which, according to Sullivan, implied that Sullivan was incompetent in his job, although it never named him specifically. The decision. The Supreme Court ruled in favor of the New York Times and denied Sullivan his defamation claim. This was done because the Constitution gives citizens and press unconditional freedom to criticize official conduct. It necessarily follows that in a case such as this, where all agree that the allegedly defamatory statements related to official conduct, the judgments for libel cannot constitutionally be sustained. And that's a direct quote from the case, the New York Times versus Sullivan in 1964. And this is the justice who decided the decision, who wrote the opinion of the court, and the photo critic is from the Library of Congress. The Supreme Court is the highest court in the land, and their decision represents the final say in this important matter. Part 2, Gertz versus Welch. Who are the parties to the case? Was the petitioner a private person or a public figure? The parties in this case were Elmer Gertz, a reputable attorney, and Robert Welch, who was publisher of American Opinion. The article was written by a journalist hired by Welch because Gertz was involved with civil litigation where a police officer named Nuccio had shot and killed a young man named Nelson. Gertz had been hired by the parents of Nelson to hold the police officer accountable. And this photo credit goes to AP Photos, but it was used by D. Schultz with permission. What were the alleged defamatory statements about Gertz in the American Opinion article? The article said that Gertz had a large police file and that Gertz was part of a communist conspiracy to discredit the police. He was accused of being involved in organizations such as the Marxist League for Industrial Democracy, originally known as the Intercollegiate Socialist Society. The article said that the National Lawyers Guild was a communist organization where Gertz was an officer and that they had planned the communist attack on the Chicago police during the 1968 Democratic Convention. According to court documents, Gertz had no police record. While he had been part of the National Lawyers Guild as an officer and member 15 years before the allegations, they had nothing to do with the 1968 Democratic Convention protests. He was not any communist or Leninist and had never been part of the Marxist League for Industrial Democracy, nor had he been involved with the Intercollegiate Socialist Society. So the verdict ultimately was that the Leninist label was a malicious libel. According to the court, the managing editor of American Opinion did not research any of the allegations and only had the article as a point of reference for Gertz's character. The necessary research to confirm his reputation was done when he took Welch to court for defamation of character. I think that these allegations must have had a deleterious impact on Gertz's reputation as an attorney and citizen of good standing in the community. It was reprehensible that such allegations were possible when nothing was done to substantiate the claims other than an empowered author with an active imagination. I would have had the person who is spoken about in the article read through it for inaccuracies before publishing it. According to the Digital Media Law Project website, Illinois recognizes that certain statements constitute defamation. These heinous statements will always be considered defamatory and are assumed to harm the plaintiff's reputation without further need to prove that harm. Illinois says it is defamation if the plaintiff is accused of committing a crime, if it indicates that the plaintiff is infected with a loathsome communicable disease, if it indicates that the plaintiff is unable to perform or lacks integrity in performing his or her employment duties. It is defamation if it attributes to the plaintiff a lack of ability or otherwise harms the plaintiff in his or her profession, or if it accuses the plaintiff of engaging in adultery or fornication. How can you relate what you learned from the Sullivan and Gertz cases to your future work in the communications industry? What I've learned from the Sullivan and Gertz cases to my future work in the communications industry cases is that it is imperative to check resources to make sure that they are valid. For example, when I worked with Ann Keegan from the Chicago Tribune for her June 3, 1996 article about my poetry reading on the beach, she asked me to read the article before it was published to confirm that it had no inaccuracies. The photo credit for the picture is Nancy Stone, the Chicago Tribune, 1996. Ann Keegan is the one who wrote the article. When I protested about my ex-husband being portrayed as a con man, she asked me if it was true. I confirmed that it was. She said, "If it's the truth, then it stays." I had a plethora of flack from my ex-husband and his girlfriend about the article because they proclaimed that he was not a con man when evidence pointed to the fact that he was. This is proof that the truth, no matter how uncomfortable, always wins. And again, photo credit goes to Nancy Stone in the Chicago Tribune in 1996. These are my references for both the pictures and the quotations. And of course, I've cited the cases here. Thank you so much.